Hi everyone, welcome to Lesson 1 of Stewart's Guide to the Law. This is labor law in the Canadian context. In this lesson, we're going to cover the separation of powers between the province and the federal government. We're going to locate labor law in the grand scheme of things. We're going to talk about where arbitrators get their power, what the limits on arbitrator power are, how arbitrator power is expanded over time, what the standard of judicial review is, and what role the courts play in the administration of labor law. So whose law is it? Most Canadian workers are regulated by provincial labor laws. The Constitution Act says that some things are provincial responsibilities and some things are federal responsibilities. It has put provincial employment, or most employment, with the province. However, it does retain things of national importance to the federal government. So federal undertakings like military bases, interprovincial trucking, which couldn't be effectively regulated by any one province because there's crossover, banking, airlines, all those things are covered under the Canadian Labour Code. But for the purposes of this presentation, we're only going to talk about Ontario law and the things that apply in the province of Ontario. So what is labor law? Labor law is the law governing relations between a union and an employer. It includes both statute and common law, so it includes laws that are passed by the legislature as well as laws that have developed through judgments and arbitration decisions over time. And it may alter the application of other statute provisions. You'll see what I mean by that in the next slide. So some laws apply to all or most workers. The Employment Standards Act applies to most workers. The Occupational Health and Safety Act applies to all workers. And the Ontario Human Rights Code applies to all workers. Once a union is certified, different rules can apply in those acts. For instance, the Employment Standard Act allows an employment standards officer to come and investigate a claim in a non-unionized workplace, but once a union is established, grievance is established as a better way to deal with that. So the Employment Standards Act, employment standards officers are no longer able to come and review what happens in those workplaces without special permission. In general, once you pass through certification, which is the process by which a union establishes power to represent the workers have more rights, not less. It does change the way some of the rights are administered, but there is no right to fair treatment. As a non-unionized employee, there's no automatic right to fair treatment, and the courts have routinely held that. But on the other hand, arbitrators have routinely held that union members and unions have the right to be treated fairly as part of the good faith provision that occurs in all collective agreements. The other thing that unionization gives you is the right to collective bargaining. So you have the right to establish a contract that both parties negotiate and no party can alter just simply by giving notice that they want to. You have to enter into the process established by the Labor Relations Act and you negotiate with each other. And the final thing is grievance. So if that contract is broken, you have the right to grieve it and go to arbitration, which we'll talk about shortly. The big thing with arbitration that normal non-unionized employees don't have is what they call specific performance. So arbitrators can offer the specific performance of an act. So they can order someone's job back, they can modify penalties, they can do things like that. Courts traditionally can only award monetary damages. So, oh, you lost your job, here's what you're entitled to as far as money, but you still don't have a job. Whereas the grievance procedure allows you to protect that through arbitrators ordering the employer to specifically perform the task of hiring you back. So what are arbitrators? Arbitrators are a neutral third party with expertise in labor and employment. Sometimes they're legally trained, but not always. They tend to have a great deal of experience arbitrating or dealing with disputes. Most arbitrators have spent some time as members or vice chairs of the Ontario Labour Relations Board, and then they go into private practice as an arbitrator. Here in Peel, most of the arbitrations we come to, we actually agree on who the arbitrator is going to be. The process for that is OPSU sends a list of names to the employers, normally 3 names, and the employer picks one. And then we canvass for dates to see if that arbitrator has any dates that work for us, and then we schedule it. If the parties can't agree to who the arbitrator is, the Ministry of Labour does maintain a list of who they consider qualified arbitrators, and you can apply to them to have the minister simply appoint an arbitrator. There are 2 types of arbitrations. The one that we talk about predominantly is rights arbitration. That's when an arbitrator settles a grievance, and the other one is interest arbitration, which is what we refer our contract dispute to, because we don't have the paramedics don't have the right to strike. So as I previously mentioned, rights arbitration is when the parties have a dispute under a collective agreement or a dispute about what's going on at the workplace. Arbitrators have a limited scope in disposing of the grievance. They're not allowed to make up new stuff. They can only read the language of the collective agreement and read what is contained in law and go from there. While the arbitrators can come up with creative solutions or solve the problem the way that they think it should be solved, in some cases, if the language isn't there, then they don't have that ability. So I think an example would be the paramedics' former collective agreement used to have an automatic termination clause for part-timers if they didn't submit availability as required and then they were warned. An arbitrator wouldn't be able to say, well, a more reasonable penalty would be a letter of suspension, because what is in the collective agreement is if this, then that. The arbitrator can't step in no matter how unfair they think that is. All they can do is discharge the language of the collective agreement. Now, arbitrators often put at the end of their grievance orders that they retain jurisdiction over the matter or the implementation of the settlement. If they don't put that, or if the settlement goes through, the arbitrator says, pay $5, and the employer pays $5, the arbitrator has discharged their function. So they no longer have jurisdiction once the party who's ordered to do something does it, and it's implemented the way that the arbitrator thought it should be. There's no going back. The arbitrator loses that function. They're no longer the arbitrator, and they become what they call functus officio, which just means their function has been discharged. The other type of arbitration is interest arbitration. This isn't as common in the world of labor relations. It's pretty common in the world of paramedicine and certainly fire and police. These are for people who have had their right to strike removed. They commonly include interest arbitration in sort of the balance of, well, we took away your right to strike, so now you get this interest arbitration. It's not exclusively for those workers. There are situations where workers who aren't essential services or designated workers can agree to interest arbitration. Currently, we've got Canadian National Railways asking Unifor to agree to binding interest arbitration, where there's no element of law that forces either party into that yet, but the employer doesn't want a service disruption because of the amount of money they make, and they're offering to go to interest arbitration because they think whatever the union wants, they won't be able to get at interest arbitration. But that's a strategic decision to offer interest arbitration in the hopes that the union members will say, yeah, you know what, union, we want you to do that. Interest arbitrators have the ability to change language. They have the ability to change how much people are paid, and they have the ability to solve workplace problems that the parties didn't see fit to solve themselves. The interesting thing about interest arbitration is traditionally the monetary settlements are higher percentage-wise, but people who work under arbitrated agreements tend to report lower levels of job satisfaction and engagement, and they generally tend to be more displeased with their work. Arbitrator power. So, rights arbitrators' jurisdiction has grown as a result of a couple of decisions. Certainly the decision in Parry Sound was the first such decision. That was a case dealing with human rights, and it was unclear to the reviewing authority whether or not the arbitrator had the ability to apply the Ontario Human Rights Code, and it went all the way to the Supreme Court of Canada, and the Supreme Court ruled that the, quote, plain and ordinary meaning of Section 48 of the Labour Relations Act, which provides that an arbitrator has the power to interpret and apply human rights and other employment-related statutes, despite any conflict between those statutes and the terms of the collective agreement, affirms that grievance arbitrators have not only the power but also the responsibility to implement and enforce the substantive rights and obligations of human rights and other employment-related statutes as if they were part of the collective agreement. Granting arbitrators the authority to enforce the substantive rights and obligations of human rights and other employment-related statutes also advances the stated purpose of the Labour Relations Act, which include promoting expeditious resolutions of workplace disputes, and has the additional advantage of bolstering human rights protection. So in Parry Sound, the court said, yeah, you not only should do that, you kind of have to as an arbitrator. And they went even further with the next decision, which is the decision in Weber versus Hydro, where they actually said that arbitrators have the exclusive jurisdiction to deal with disputes that arise amongst the parties. But in that decision, they didn't limit the parties simply to the union and the employer. They also sort of vaguely talked about other parties that might kind of be part of the collective agreement. The biggest problem with that decision is we don't know where it ends. There is sort of a thought that if an insurance claim is rejected, then the appropriate forum for that isn't court. The appropriate forum is labor arbitration. But the parties don't have any means to compel the insurance company to even attend the arbitration, and the insurance company isn't bound by the arbitrator's jurisdiction because only the parties to the collective agreement have agreed to involve the arbitrator. So it's a little unclear. That's sort of muddy waters of labor relations. We know definitely that human rights statutes apply. We know definitely that occupational health and safety statutes can be ruled on by arbitrators. We know that they can adjudicate tort claims, but again, if the tort is done by someone who the company isn't vicariously liable for, it's unclear whether that's enforceable. So these are things that are still kind of being developed in labor law. Arbitration is final and binding. It only works if the parties can actually get an answer. Otherwise, it's just somebody who's an expert who has an opinion, which is nice, but doesn't help the parties. It doesn't make financial sense for them to go to somebody just to get their opinion. Ultimately, everything in labor law is geared towards continuing the relationship of the union and the employer, and that means settling disputes. Most cases, there is no ability to appeal an arbitrator's decision. There's no competent court that you can go to and say, hey, I want to appeal this decision because I didn't like it. Human rights claims are a glaring exception to that. They can be appealed to the Ontario Human Rights Tribunal. The interesting thing about that is the grievance is actually in the hands of the union, so the union gets to pick how to go forth with the grievance, but the individual can actually apply to the Ontario Human Rights Tribunal, and the reason for that is to guard against people who feel to guard people who feel they're being abused, possibly by their union, and that the union isn't doing the right thing with their human rights. Human rights are a personal right. They're not a collective right like a lot of our employment rights are as members of a union. So in order to solve that, the legislature has said, well, you can use the Ontario Human Rights Tribunal essentially as a court of appeal to grievances that are filed under human rights. There is something called judicial review, which is where a judge reviews the decision of an arbitrator, and that can sometimes be an option. There's two different standards for judicial review, or what would cause a judge to say, no, that's not an appropriate settlement, Mr. Arbitrator. The first one is for home statutes like occupational health and safety, human rights, employment standards, the collective agreement. The standard is reasonableness. So it doesn't have to necessarily be correct. The party who disputes the ruling, simply proving that the ruling is not correct, will not be successful in a judicial review. It has to be something that is unreasonable. And the reason for that is that labor arbitrators are considered experts in labor. They're considered experts in employment, and the courts cut them a pretty wide berth for doing their job, because ultimately they're the experts. They're the person who the legislature has said, you know what, you guys have oversight over this realm, so we want you to exercise it. But with the expansion that's happened in the jurisdiction of arbitrators into things like tort law, and tort law is when one party makes a claim for an inherent wrong done to them, or things like constitutional challenges where they're saying, no, actually, the way that this was being interpreted would actually violate my constitutional rights. The court holds the arbitrators who go away from their home statutes to a higher standard, and that standard is correctness. So they don't only have to be reasonable, they actually have to get it right when they're dealing outside of their home statutes, or the things that are normally part of their work. So that it's just that higher standard, and when you read decisions that go into the muddy waters that are there, those decisions tend to be a lot longer, and they tend to spend a lot more time being precise with why they're doing what they're doing, interpreting law that isn't part of their normal bailiwick. So what is the role of the courts? The role of the courts is extremely limited in employment and labor law. There is the role of judicial review, but that is the exception to the rule, not the rule itself. And you have to get permission from a court of appeal to even file a judicial review. There's sort of an ancillary role where if you file a grievance and the grievance is continuing, there's the opportunity to get a court injunction to stop the other party from violating the rule in the interim. So you could theoretically go to a common court and get an injunctive, it's called injunctive relief, which basically get an injunction against the other party saying, stop that. The other big role in the courts is, I guess, the final role is if an arbitrator's ruling is not being obeyed by the party who has the ruling, then you file it in a court for enforcement, and then you can be held in contempt of court for not obeying that ruling, and you can be fined and jailed. So that's, I guess, the final role for the courts. So to review, you got rights arbitrators. They get their power both from the statute, the Labor Relations Act, and from collective agreements that say, hey, we're going to appoint an arbitrator to be the final and binding person for any disputes that arise under this collective agreement. Incidentally, if it's not in the collective agreement, the Labor Relations Act says, well, we're going to pretend it is, and here's a clause that says it is. The rulings are binding on both parties, so sometimes it's a right-out win for the employer, sometimes it's a right-out win for the union, and sometimes both parties are happy, and sometimes both parties are not happy. Rights arbitrators have the ability to deal with any employment issues or things that occur out of the employment relationship. Then they're held to a standard of reasonableness for employment-related statutes and matters, and correctness for other matters that sort of arise, other types of law. Rights arbitrators absolutely do not have the power to alter the language in the collective agreement. The only thing they can do is apply the language that's in the collective agreement, which we contrast against interest arbitrators who get their who can alter the collective agreement. They get their power again from statute, not normally the Labor Relations Act. It's normally some other act, like the Crown Employees Bargaining Act, or the Ambulance Service Collective Bargaining Act, or the Fire Services Act, or the Police Services Act. That's normally where an interest arbitrator gets their power is the act that designates someone as an essential service or a portion of the workers as essential, is where interest arbitrators get their power. And they are authorized again to change collective agreements. That's their whole role, is what should this collective agreement say. Their cases aren't built strictly on legal principles like rights arbitrators generally see. Normally, interest arbitrators get economic data. In private enterprise, they can get profit data. And in order to sort of make informed, economically feasible decisions, because again, the purpose of all of labor law is to continue the relationship. And if an interest arbitrator orders a contract that would make the employer discontinue operations because it went bankrupt, that wouldn't be in keeping with sort of the purpose of the whole gambit. We talked about the courts having a limited role in labor relations. It is an essential role in that the arbitrator's decisions can only be enforced with the help of the courts, but it is a limited role nonetheless. The arbitrators are really the ones who are in the driver's seat when it comes to labor relations law. And we talked a little bit about where that law comes from. And we know that most employment is provincially regulated, certainly unless it's otherwise specified it's provincially regulated. And we talked about some of the things that were federally regulated, like airlines and interprovincial truckings and trucking companies, and federal undertakings like military bases and federal power plants and things like that. So that is lesson 1. Lesson 2 will be coming next week. I'm going to try and get it up as soon as possible, but there's been some pretty big news in what our Constitution says our freedom of association actually means. The Supreme Court has been hard at work making the material I've already prepared obsolete. So I'm working hard to amend it and get the right message on it there. But yeah, stay tuned for that. And if you have any questions, feel free to post them to the forum or to email me.